Trapmore gang, there's some new Durk paperwork that's just dropped. So let's get into it. So basically, Durk's imaginary manager, Durk All Day on Twitter, has been providing all of the paperwork recently. It's been really helpful. Shout out to them. I feel like it's extremely positive and transparent that somebody is actually archiving and documenting all of this paperwork so that everybody can see it and read it and make up their minds about what's inside this paperwork. So basically what's happened is we've got the latest update, and basically in this one, Durk, Dee, Boogie, and Brown Eyes have all filed a motion to dismiss, with prejudice, disqualify all charges and the entire prosecution team. So what this means, right? Basically, there's more to it. I'll just read the tweets. It says, Magistrate Judge Donahue and lead prosecutor AUSA Yaniello had received threats specifically that mentioned Durk and Dee. And we talked in previous videos about threats that had been made to the courthouse and prosecutors and judges and people that have been involved in this case basically being threatened by alleged OTF fans. And it appeared from the last paperwork that there was actually a mention of some redacted, sealed information that would seem to suggest that somebody involved in the crew had done something to basically maybe was making it harder for witnesses to do their thing. So anyway, after this, it says the government relayed all those threats to all judges in the district, but not the defendants. It says the defense wasn't told until October, after months of litigation in front of judges who had been threatened and kept it quiet. So it says they want the whole thing dismissed, disqualification of the entire bench and the U.S. Attorney's Office. Judge Donahue received threats mentioning Durk in February, sat on it, and Durk was in front of that same judge in May for a detention hearing. Of course, she denied his release. Now, I would say that Durk's imaginary manager is maybe putting a little bit of his own opinion here when he says, of course, she denied his release. It seems like maybe he's inferring that there's a bias. So of course, the judge denied his release because there were threats being made. But anyway, I won't give any more analysis on that. So in this follow-up post, Durk's imaginary manager comments on the paperwork, and I do have the full paperwork, but right now I just want to read the tweets. It says, if the immediate dismissal or disqualification is not granted, it says, stop everything. The trial too. Have a hearing on who knew what. Have a hearing on who knew what and when. Threat-related materials or in-camera review of it. Give case to a judge outside of CACD. Basically, they want a judge, I guess, outside of California, and vacate all orders entered during the non-disclosure period. So I've got the full paperwork here. I haven't read through it and made notes and, put down kind of my thoughts on what's inside it this time. And I guess I'll just scroll through and, just read a couple parts that I guess are interesting. So it says here at the start, it says, for more than 7 months, the prosecution team concealed from the defendants that both the presiding magistrate judge and lead trial prosecutor received violent, case-specific death threats made while invoking the names of Durk Banks and DeAndre Wilson. This prolonged non-disclosure, compounded by undisclosed ex parte communications between the prosecution team and the bench about these threats, has irreparably compromised the structural integrity of these proceedings. By February the 25th, 2025, at the latest, the government and district court knew that Magistrate Judge Patricia Donahue had received 4 explicit voicemails threatening her life and courthouse personnel. On April the 25th, 2025, lead prosecutor AUSA Ian Yaniello received similar death threats directed at him and all courthouse staff. The U.S. Attorney's Office, in carrying out a secret investigation, relayed the threats to all judges in the Central District of California, including this court. Yet defendants learned nothing of these threats until October the 1st, 2025, after months of litigation before judges who knew of the threats but remained silent and just days before pre-trial motions were due. Threats of violence against judges and prosecutors strike at the heart of our constitutional order. When individuals seek to intimidate those administering justice, they attack not just individuals but the rule of law itself. The undersigned and their clients unequivocally denounce the reprehensible threats against Judge Donahue, the AUSA Yaniello, and the courthouse personnel. The government's response to these threats, however, concealing them while continuing to prosecute defendants before judges who were themselves intended targets, violated fundamental constitutional guarantees. The prosecution's 7-month silence deprived defendants of their Fifth and Sixth Amendment rights to due process and an impartial tribunal. During this period, defendants unknowingly litigated critical matters, including detention proceedings and pretrial motions, before judicial officers operating under the cloud of undisclosed threats. This concealment prevented defendants from seeking recusal, challenging the fairness of proceedings, or making informed strategic decisions. The resulting appearance of partiality, amplified by ex parte discussions between the bench and prosecution about threats directly implicating defendants, has created an incurable breach of judicial neutrality that no less a remedy than full recusal of the Central District Bench can cure. They want the whole district bench recused. The integrity of criminal prosecutions depends on transparency and impartiality. Here, both were fatally compromised because these violations strike at the core of due process and the constitutional guarantee of receiving fair hearings in front of an impartial decision-maker. Dismissal is the only adequate remedy. Additionally, the line prosecutors, especially AUSA Yaniello, must be barred from participating in the prosecution of this case, and because it appears the entire U.S. Attorney's Office for the Central District of California participated in the investigation, the entire office must be disqualified. Finally, given that USAO sought a superseding indictment against the defendants just days after being directly threatened in their name, the indictment must be dismissed. The fact that USAO concealed the information and only revealed it to support its extraordinary motion to impanel an anonymous jury demands that the indictment be dismissed with prejudice. No lesser sanctions can restore public confidence in the fairness of this prosecution or cure the prejudice flowing from the months of secret communications and judicial proceedings conducted under these extraordinary circumstances. Now, we have already talked about in previous videos how some of this stuff was already mentioned, and it was disclosed, I think, at the start of October. But this basically just kind of, it breaks down their timeline of like how this all how this played out, and then how it was actually presented in a way that Durk and his team found out about it. It says February the 22nd, 2025, 4 threatening voicemails to Judge Donahue referencing Durk and threatening her. I think is it a woman? I don't know if it's a woman or a man. Threatening them, Judge Donahue and courthouse personnel. 3 days after that, on February the 25th, USMS contacts Chambers and USAO. FBI opens an investigation. S.A. Cochran becomes FBI point of contact and actively investigates threats. Now, if you were one of the people that think it is cool to call up a courthouse and threaten a judge on behalf of OTF, you're a dummy, and the FBI will be on your ass. And, who knows if that's a good thing. April the 28th, 2025. Threatening call was made to AUSA Yaniello. Yaniello. That's a crazy name. It kind of rolls off the tongue, Yaniello. With death threats to AUSA Yaniello and courthouse USAO personnel. On May the 1st, 2025, the United States Attorney's Office... I'm tired of this nonsense, man. Obtained a second superseding indictment in this case, docket 147. May the 8th, 2025, detention hearing before Judge Donahue, threat still undisclosed to defense. June the 2nd, 2025, detention hearing on pretrial motion hearing on defendant's motion to disclose grand jury transcripts before Judge Fitzgerald. Threat still undisclosed to defense, continued detention ordered, ruling pending on motion to disclose. August the 6th and 13th, 2025, there were conferences between prosecution team and undersigned defense counsel, RE anonymous jury, and the threats were still undisclosed. So they're saying all of this time passed, you didn't disclose the threats. And then it says October the 1st, 2025, first partial disclosure of threats by the government. Defense makes oral demands for immediate disclosure of all relevant material. Oh, God. Oh, I'm tired. My yawns, me saying I'm tired of this nonsense is just me tired of doing all this work. There's been stuff behind the scenes that's pissed me off. That's not me talking about what's actually in here. But I'm sure some people might not take that way. It says October the 1st, 2025, first partial disclosure of threats by the government. Defense makes oral demands for immediate disclosure of all relevant materials and communication about the threats. October the 9th and 14th, 2025, the defense wrote discovery demand letters. October the 23rd, 2025, the government's letter and selective disclosures about threats. Okay, and then this details the threats. Somebody basically called, they mentioned Durk and Dee Dee by name, and says if they get life, I'm going to burn this something to the ground. I'm talking about the world. I'm going to burn it to the ground. On the voicemails, the caller urges the judge to do the right thing and free Durk and Dee Dee. Okay. And basically, it just goes on to detail that, and we've detailed that in other videos, and they're basically just, it's a very long document. It's a 48-page document. I didn't do what I did last time because I don't think that was well received. But yeah, you can go and check this out on Durk All Day on Twitter. You can kind of go and make your own conclusion about this. It's 48 pages, so go and check out that document, man, and go and make your own mind up about this document. So yeah, well, there you have it, right? They want to disqualify all judges of the United States District Court for the Central District of California, and they want to just dismiss the second superseding indictment with prejudice. Basically, just have this whole thing go away. Is that likely to happen? Couldn't possibly say. Let me know down in the comments what you guys think, and if you enjoyed this video, let me know. If you didn't, let me know, man, and I'll be back with some more content, and we'll just see how this develops from here. Hope that was a good one. Bye.